Thank you to everybody who joined on time. I'm going to give it about another minute and a half for everybody to trickle in from the waiting room, and then we'll get started. All right, I've got 2 minutes after the hour, and even though I see a couple people still trickling in from the waiting room, we'll ease our way in deference to everyone's time. Thank you so much for joining us for this very timely ABA webinar, Speaking Out from Inside, Freedom of Speech and Government Whistleblowers. Um, we're thrilled to be presenting this webinar on behalf of the ABA section of Civil Rights and Social Justice. The section is actively planning additional programming on a variety of issues, so we invite you to please visit americanbar.org/CRSJ, Constitutional Civil Rights Social Justice, for updates on all these programs. During today's programming, we really encourage you to make this interactive, get in there and ask questions of our panelists, but please use the Q&A feature and not the chat feature. If you're not seeing the Q&A controls, please ensure that your screen is not idle. Maybe move the mouse around, and we'll be monitoring the Q&A. We'll do our best to address your questions, time permitting. Also, we'll share a recording of this program with everyone who registered. You'll be able to share that YouTube link widely with your networks, which we would love for you to do. So my name is Frank Lamani. I'm a legal counsel to CNN and also teach at the University of Georgia School of Law. I'll be your moderator today in my role as co-chair of the Free Speech and Free Press Committee of the section. We have a really illustrious group of experts today to talk about the subject of the First Amendment as it applies in the government workplace. And so I'm going to talk very little and turn the mic over to them shortly. But just by way of quick introduction, let me introduce each of our speakers alphabetically. We have Hampton Dellinger joining us. He is special counsel in the U.S. Office of Special Counsel. He's a former assistant United States Attorney General. He's been a partner at the Boies Schiller and the Womble Carlyle law firms, former counsel to the governor of North Carolina, and he was sworn into his present position at the Office of Special Counsel in March of this year. Caroline Hendrie is with us. She is the executive director of the Society of Professional Journalists. She was appointed earlier this year in May to head the nation's largest and most diversified membership organization for working journalists after a long career in both the journalism and the nonprofit field. As a journalist, she rose to the position of managing editor at Education Week magazine, which she left in 2010 to become executive director of the Education Writers Association, which provides training in support of America's education journalists. Ramya Krishnan is with us. She is senior staff attorney at the Knight First Amendment Institute at Columbia University. She has worked there since August of 2017 on a range of cases implicating the constitutional right of free expression. She came to Columbia University from Australia, where she worked as a government solicitor and as a law clerk to a justice on the Supreme Court of New South Wales. And Judge Mimi Tsankov is with us. She has served for 18 years as an immigration judge and since 2021 has been president of the National Association of Immigration Judges. She teaches as an adjunct professor at Fordham University School of Law, and she's a widely published speaker and presenter and author on the subject of immigration law. And I should mention, we're joined by an unadvertised, but still very much welcome special guest, Emily Collier. She is the Acting Associate Special Counsel overseeing the Investigations and Prosecution Division in the Office of Special Counsel, which she joined in 2010. And she's going to bring that decade and a half of experience to bear if we get into the weeds of any complicated whistleblower questions. So thank you, Emily. I just want to kick this off by explaining a little bit about why we chose this topic. The subject of the First Amendment rights of public employees is front and center these days because it's being litigated quite a bit, even as we speak. You can't go a week without another case in the news headlines about an employee getting into disciplinary trouble, often for what they have said on social media that somehow indicates questions about their fitness to serve in their public employee capacity. Those cases are interesting and they're important for sure, but what we're primarily focused on today is not the individual off the reservation social media comment, but rather these blanket rules which are pervasive across all levels of government that forbid government employees from sharing the benefit of their expertise and knowledge with the public. The Society of Professional Journalists, where Caroline works, has an entire page, Gagged America, that is dedicated to focusing on the problem of government gag rules that get between the public and information from government experts. And I'm sure she'll take some time to talk about that. Shout out to my old employer, the Bruckner Center for Freedom of Information at bruckner.org, which has also collected a series of research papers analyzing the constitutionality of these rules that forbid public employees from speaking publicly about the subject of their work. So with that, I want to invite Ramya to first give us the First Amendment 101 with the benefit of your expertise as a scholar and a litigator about, we know, Ramya, that in outside of the public workplace, that the First Amendment is really powerful medicine. There's almost nothing that the government can do to you short of, threatening to kill the president or offering to sell somebody some child pornography. There's almost nothing that the government can do to punish you for the content of your speech. But we also know that sometimes those First Amendment principles relax a little bit when the speaker is not just a citizen versus a regulator, but an employee versus their employer. So maybe you can kind of tee us up the lay of the land in the First Amendment and public employment.
Absolutely. And I want to just start by thanking the ABA for inviting me to join this great panel on a very topical issue. So the starting point is really that government employers at all levels, whether you're talking about a federal agency or a local police department, they all have to supervise their employees in a manner that is consistent with the First Amendment. Now, that doesn't mean that the rights of public employees are absolute or even as extensive as they would be outside of the public employment context. And that's because the court has recognized that to efficiently provide public services, a government employer has to have more latitude to supervise its employees than when it regulates its citizens. And this really just flows from the understanding that if employees possessed the same First Amendment rights as citizens, the workplace would quickly become unmanageable, and the government wouldn't be able to do its primary job. So this really, the recognition that public employees have First Amendment rights goes back to a 1968 case called Pickering versus Board of Education, where the court announced a balancing test to determine whether a public employee's First Amendment rights have been infringed. And in that case, you had a teacher, Marvin Pickering, who had been fired after he wrote a letter to a local newspaper criticizing a proposed tax increase and the local Board of Education spending priorities. And Pickering argued that this firing involved retaliation against First Amendment protected speech, and the court agreed. And in reaching that result, the court rejected the theory that because public employment can be denied altogether, it may also be subjected to any speech restriction, no matter how unreasonable. In the court's view, a balance had to be struck between, and I'm quoting here, the interests of the employee as a citizen in commenting upon matters of public concern, and the interest of the state as an employer in promoting the efficiency of the public services it performs through its employees. Then you had a case called Connick versus Myers from the 1980s, where the court clarified what public concern meant in the context of the test announced by Pickering, and it held that the First Amendment does not bar workplace sanctions when an employee speaks only on matters of personal significance. Then you had Garcetti versus Ceballos, a case from 2006, where the court decided that an employee is not entitled to First Amendment protection when they speak pursuant to their official duties. In that case, you had a deputy district attorney who had written a memorandum to a supervisor concluding that an affidavit that had been used to obtain a search warrant contained serious misrepresentations. And the court held that these statements were unprotected because they were made pursuant to that district attorney's official duties. And then the final case I want to mention is a case called NTEU, which is a case from 1995. And in that case, the court recognized that the Pickering analysis can't be mechanically transposed to prior restraints, or what Frank earlier referred to as blanket rules that prohibit employees from engaging in certain kinds of speech in their private capacities. The court there was confronting a First Amendment challenge to a federal regulation that prohibited federal employees from accepting honorarium payments in exchange for outside speaking engagements. And the court noted that the statute before it involved a wholesale deterrent to a broad category of expression by many, many, many employees. And so it implicated far more serious First Amendment concerns than the isolated disciplinary sanction that was at issue in the Pickering case. And so it tweaked the Pickering balancing test to account for these more serious concerns. And it held that the government in such a case must show that the interests, and I'm quoting again here now, the interests of both potential audiences and a vast group of present and future employees in a broad range of present and future expression are outweighed by the expression's necessary impact on the actual operation of government. And the reason, that is such a significant modification to the Pickering test is what the court is saying is you don't just take into account this individual employee's interest in speaking as a citizen on matters of public concern. When you're looking at a blanket rule, you have to look at all of the employees, past and present, that are potentially covered by this policy. Consider their interests in speaking, but also consider the public's interest in receiving this speech and these insights that government employees want to be in a position to share with them. And so the First Amendment interests, on the one side of the balance are far more weighty than those present in a case, for example, challenging a firing as in Pickering. And the court has subsequently said, this higher burden more closely resembles exacting scrutiny, which is a far more sort of stringent standard of scrutiny than the sort of reasonableness analysis that Pickering calls for. So that's sort of a lay of the land when it comes to sort of public employee speech and the sort of key cases and standards involved in this context. I'll leave it there.
Thank you so much. And there's a really good question in the Q&A that I'm just going to put a pin in and circle back to, because I think it's a Ramya question, and maybe you can look at the Q&A and be thinking about your answer to this with your First Amendment litigator expertise hat on. Just by way of emphasis before I pass the baton, because this is a good case to mention by way of transition to Hampton and his work. There is another First Amendment case following, and in my view, significantly narrowing the Garcetti principle, called the Lane versus Franks case from 2014. And I think it's valuable to also touch on that one, because the Garcetti case, for I think many years, planted the idea with government employers that they had essentially plenary control over everything that employees said, period, full stop. And in Lane versus Franks, a unanimous Supreme Court came back and in fact said, no, that's an incorrect understanding of Garcetti. And Garcetti is really limited to a rather narrow subset of speech where the speech itself is your work assignment. That is, you're assigned, as in the Garcetti versus Savallo case, to write a memo. And you write a memo in a way that undermines your employer's interests. Well, you were being paid to do that on the clock as part of your job. And that writing assignment was an assignment that needs to be done in a way that comports with your employer's instructions. But the Lane v. Franks case was a very different case. And it was the kind of case that Dellinger's agency works on. It was a classic whistleblower case involving a person who had become aware of waste, fraud, and corruption inside of the Alabama community college system and blew the whistle on it. And that speech, says the court, is protected speech. It's not a Garcetti work assignment. And so we have this interesting dynamic here where if the speech is something that you're actually assigned to do as part of your 9-to-5 working responsibilities, that's Garcetti speech, essentially zero First Amendment protection for that, but still a realm of robust First Amendment protection for what we would regard as true whistleblowing speech. And with that, let's pass the mic to Hampton Dellinger to talk about, I guess, first explain to people who may be confused by the nomenclature what the Office of Special Counsel is, what it does, what your role is in whistleblower protection, and what you have been doing in recent years to kind of invigorate that work.
Well, thanks, Frank, and thanks to the ABA. I'm Hampton Dellinger, honored to be here and very glad to be joined by my colleague, Emily Collier, who helps lead the Office of Special Counsel and is the true expert between the two of us on protecting the rights of federal employee whistleblowers. To your question, Frank, let me say what the Special Counsel is not before I say what we are. We are not related to the special counsels appointed by the Justice Department on a one-off basis, for example, Jack Smith. So we have no criminal authority or jurisdiction. What we are is a completely independent federal agency that does a number of watchdog related things. And particular for our gathering today, we protect federal employees, especially whistleblowers, and we enforce the Hatch Act, which prohibits federal employees from engaging in partisan politics on the job and has some restrictions for their off-the-clock political activities. Our universe, our ambit, our jurisdiction in the Office of Special Counsel are all federal civilian employees. So that does not include active duty military, does not include government and contractors. We have some limited jurisdiction over state and federal employees for purposes of Hatch Act enforcement. And we have a limited role, but not complete authority with regards to the intelligence community. But that leaves over 2 million federal employees that we are able to protect in different ways. And if I could just take a few minutes to tick off a couple of keys to understanding OSC's mission and our mindset. First, I want to make it clear that our enforcement is not animated by my personal beliefs. It is not dependent on who's president. It is driven by my reading, Emily's reading, our colleagues' good faith reading of the laws passed by Congress, plus any gloss put on them by the courts, including the Merit Systems Protection Board. And we've started, understandably, with constitutional protections for government employees' speech, but our focus is on the statutory protections for federal employees, and I think they are meaningful and robust. They can be found I know we're not getting CLE, but can't hurt to mention a statute or two. At Title V of the U.S. Code, particularly 5 U.S.C. 1211 through 1219, which sets out the authorities of the Office of Special Counsel, and 5 U.S.C. 2302, which lists a number of prohibited personnel practices, which basically provides a substance for the protections for federal employees. But let me say what the definition of whistleblowing is for purposes of those statutes, because it's really important and it really is our focus. It's any violation, if you disclose as a federal employee whistleblower, any violation of a federal law, rule, or regulation, of gross mismanagement, of gross waste of funds, of an abuse of authority, of a substantial and specific danger to public health and safety, or of scientific censorship, that is protected whistleblowing. And then let me say who you can whistleblow to as a federal employee: to Congress, to inspectors general, to my office, to the media, to the public. So to my mind, Congress very intentionally put in the statutes a broad definition of what whistleblowing is and the broadest definition of who you can whistleblow to and enjoy protections. Congress has also said in the statutes the federal government cannot impose any policy, form, or agreement that curtails whistleblowing. So, and Congress has dictated the precise language that any non-disclosure agreement or any policy that a federal agency institutes, the exact language that employees need to receive so that they understand they can continue to whistleblow, to provide information about any violation of law, rule, or regulation. And we police, because Congress was so specific about what that language has to be, the carve-outs for NDAs, we police that very aggressively, and they're really open and shut cases. The other thing that the statute says is that whistleblowers cannot suffer any adverse employment action as a result of their whistleblowing. And my agency is always at the ready to support whistleblowers who have been retaliated against. And we will, if we have to, bring cases in front of the Merit Systems Protection Board. Many times we will bring what we believe is compelling evidence to the attention of agencies, and they will resolve the matter. And we're getting employees reinstated. We're getting them hundreds of thousands of dollars in back pay and other damages. And information about that's available at our website at www.osc.gov. With regards to the Hatch Act, I've worked mightily to balance and achieve two goals. One is to meaningfully enforce the Hatch Act. We need to have a politics-free zone at work for federal employees. That's the heart of the merit-based system. At the same time, I recognize both statutorily and constitutional protections for federal employees to speak, and that includes on the job. And so I've tried to make sure that people understand my view that federal employees can talk about issues of policy, issues of the day, even if they touch tangentially, inadvertently, incidentally on politics. In terms of other protections that I want to highlight, federal employees cannot be discriminated against because of their political affiliation or views expressed off the clock, as long as they're complying with the Hatch Act. They can't be discriminated against for any conduct which can't be shown to adversely affect their job performance. And so the bottom line is that I know federal employees are citizens. They're also informed, they're knowledgeable, and they're experts. And their voices deserve to be heard and need to be heard. And Congress and the courts have made that clear. And so what Emily and I and our colleagues do every day is everything we can do to protect and promote speech by protecting and promoting the speakers. Emily, anything to add?
I think that was a great summary. There are actually a number of prohibited personnel practices that implicate public speech protections for federal employees. And I know it can be a little bit of a maze to figure out which ones apply to a given set of facts, especially for people who are coming to us pro se, which is very common. So I wanted to give a shout out in particular to our Department of Outreach and Training which have a lot of great sort of educational resources to help sort through which protections might apply to a given set of facts, and also which employees can file with our office. So there will be some links, I think, provided to the attendees, including our web filing portal if you have questions about how to file with us, and questions also about which of these prohibited personnel practices might apply to an employee's specific situation.
Emily, while we have you on the screen, there's a good question that I feel like we ought to go ahead and take now, because Mr. Dellinger identified some of the categories of employees who can and cannot take advantage of the federal statutory whistleblower protections. What about tribal government employees? Is that a category of employee that is or is not covered?
Right. So our definition of employee is mostly constrained to Title V employees. There are some exceptions and it can get a little bit nuanced. So I would encourage people to sort of reach out and have at the ready their documentation about the type of their appointment, and we can sort of help them sort that out. But as a general rule, I think we're looking at mostly Title V federal employees.
Got it. Thanks for that clarification. And I want to offer, by way of supplement to Hamp Dellinger's good remarks, everything that he has talked about applies in the federal workplace, but as we know, many government employees work in state and local government, and your mileage may vary quite a bit in those contexts. It's quite true that there are statutory protections at the federal level that might kick in for somebody that engages in whistleblowing to the general public or to the news media, but that is not always reliably the case at the state and local government level. There are many states where the whistleblower protection statute applies only to internal up the chain of command of whistleblowing, so that a complaint can be protected if you go to your supervisor, if you go to the state attorney general, if you go to a prosecutor, but not necessarily, varying by state, to the news media or to the general public. And so for those who are practicing in that area, it's always important to consult the body of law that applies in your jurisdiction, because not everyone is as robust as the federal law. And with that, I think that's a good segue for me to talk, to turn the mic to Judge Mimi Tsankov. Judge Tsankov, you've both been, as president of the association, a litigant challenging the silencing of federal employees, and also have engaged in some what might be termed whistleblowing speech yourself. And so please share with us from the standpoint of the government employee who is subject to these constraints, why is it important for people like you to have the ability to share the benefit of their expertise and knowledge with the public?
Well, thank you so much, Frank. I just want to first just begin by reiterating the fact that I am speaking in my role as president of the National Association of Immigration Judges. We're a labor organization, and it's affiliated with the International Federation of Technical and Professional Engineers. So here's the disclaimer that I must present. The views expressed here represent my personal opinions or those of the NAIJ and do not represent the official views of the Department of Justice or the Executive Office for Immigration Review. So let's go ahead, getting to your question. I want to start with some context. First, I am a member of the Administrative Judiciary, and I preside at the Immigration Court in New York City. But as I mentioned, I'm not speaking in that context. I'm speaking as that elected president of the non-supervisory immigration judges throughout the United States, and that's about 700 judges. So we are a court, and we're located within the Department of Justice. And our judges preside at immigration court removal hearings at the roughly 70 immigration courts around the country. So from that vantage point, I do get an opportunity to become aware of how the courts are run, when changes in policy are introduced, and to understand the working conditions of our judges. Now, historically, the immigration judges have played a critical role in civic education and engagement. In fact, judges in the Article 1 courts, the Article 2 and Article 3 courts have all done so, and it's been encouraged. Just looking at one of Chief Justice Roberts' comments, he explained that in our age, and this is a quote, when social media can instantly spread rumor and false information on a grand scale, the public's need to understand our government and the protections it provides is more vital than ever. And he says that the judiciary has played an important role in civic education. So as immigration judges, it's clear that our expertise and our experience does give us these unique insights into the strengths and sometimes the flaws of the law and the court system. We take our role very seriously, and for many years, immigration judges have been active members of the community. They speak to lawyers and non-lawyers alike about the law generally, and the immigration system in particular. We've held leadership positions in law associations for decades. In fact, former immigration chief judge William Roby, he served as the president of the Federal Bar Association while he was a sitting immigration court chief immigration judge. Unfortunately, these days, the U.S. immigration court system, once again, not a member of the third branch of government, but rather just an agency within the U.S. Department of Justice, does not always share this commitment to civic education. Instead, judges are quite tightly managed by the Department of Justice, and at times it has severely limited the ability of immigration judges to speak publicly. Furthermore, it scrutinizes what judges are saying and to whom for all outside speaking on immigration topics. A high-profile example of this occurred back in 2012 when immigration judge Ashley Tabador was barred from hearing immigration cases involving Iranian citizens after she had accepted a White House invitation to attend a roundtable of Iranian American community leaders. Judge Tabador herself, an Iranian American, had sought and received DOJ permission to attend the event, but was then ordered to recuse herself from presiding over all cases involving Iranians. The DOJ offered some might say, twisted rationale that there was somehow an appearance of bias because she was a prominent advocate for the Iranian American community. However, we know that any argument like this has no outside boundary and could presumably be used to bar anyone active in their ethnic or religious community from presiding over cases from that group. Eventually, Judge Tabador brought suit in federal district court, alleging violations of her First Amendment rights and employment discrimination under the Civil Rights Act. And the DOJ ultimately settled the suit a year later, reversing their recusal order and paying Judge Tabador's law firm almost $200,000 in attorney's fees plus damages to Judge Tabador. The DOJ also did agree to review its recusal policies. Fast forward to 2017, we saw a real sharp change in severe restrictions on the ability of immigration judges to speak publicly under a new set of very restrictive speaking policies. Those 2017 policies barred judges from speaking about immigration law or policy or the immigration court system in their personal capacities. And the DOJ defined all immigration-related speaking engagements as official capacity speech, and then repeatedly denied requests by judges to speak at bar association events, law schools, and even in some cases to seventh graders at a local public middle school. So here's an example of the types of programs that were problematic. The DOJ denied a request by one judge to speak to law students at an immigration clinic about immigration court etiquette, and its rationale, as set out in an email to the judge signed only by the speaking engagement team, was that the judge might be, quote unquote, unprepared to present the department's official view when presented with thorny questions and topics, end quote. That denial stressed the importance of only management officials talking about immigration publicly, and this is a quote, in order to present a consistent nationwide message to all Executive Office for Immigration Review stakeholders and the public. So clearly, any statements by immigration judges contrary to that official line were unwelcome and forbidden. And we're concerned that these severe limitations on the ability of the immigration judges to engage in public dialogue on immigration topics, as NAIJ, was occurring. Fortunately, the Knight First Amendment Institute at Columbia University filed a lawsuit demanding that that policy be dramatically rewritten. And Ramya here is going to talk a little bit about that in a few minutes. But in the meantime, I wanted to note that throughout the last few years, the DOJ has revised its policies, but they've done so without input from our organization. And the new policies continue to bar immigration judges speaking in their personal capacities about immigration unless the content of the speech has been pre-cleared by layers of immigration court management. The nature of these policies has led to recent clashes as well. Earlier this year, in my role as the leader of the NAIJ, I was subject to a new policy explicitly barring union leaders from speaking in their association and personal capacities about the immigration court without pre-clearance by layers of immigration court management. As some may know, I have testified in the past before the Senate and the House of Representatives on the working conditions of immigration judges. And this action by the DOJ actually triggered bipartisan concerns and even caught the attention of the Office of Special Counsel, ultimately leading to a retreat from that new policy. Look, we know that promoting judges' civic engagement is an important part of a healthy judiciary. Chief Justice Roberts himself wrote in 2019, "I ask my judicial colleagues to continue their efforts to promote public confidence in the judiciary through both rulings and civic outreach." So I'm here today to participate in this program and to say that that message isn't always trickling down successfully, in some instances. And we appreciate all efforts that are being made to make federal employees feel more comfortable to make sure that the information is getting out. And I'll leave it there. Thank you.
Thank you. Well, and as somebody who's practiced just a little bit in that venue, and I can recall vividly that as of just a couple years ago, at least one judge was still using a 1970s cassette tape recorder in his courtroom instead of a modern court reporter. I'm very familiar with the conditions under which you work there. I'm going to take this just a little out of order because I think it flows better. And Caroline, I'll get to you in SPJ in just a moment. But Ramya, would you mind, since we're on the subject, just bring us up to speed on where the National Immigration Judges litigation stands, because it's sort of emblematic of how challenging it is to get the substance and the merits of one of these free speech cases in front of a court to be tried.
Yeah, absolutely. I mean, we challenged the policy that Judge Tsankov was just talking about in 2020, and we've been stuck for 4 years litigating the question whether NAIJ is able to raise these claims at all in federal court, or whether they have to raise their claims administratively through a protracted process that might never yield judicial review. And so initially, I mean, NAIJ was a certified union, and the government argued that it was required to raise its claims under a statutory scheme that is intended to sort of resolve claims arising from federal labor disputes. Since its decertification, they've now argued that their claims first need to be raised before the Office of Special Counsel through a process, again, that might never yield judicial review. And as you say, Frank, it's just emblematic of how difficult it is to actually get a hearing of what I think are very strong First Amendment challenges to these blanket prohibitions on government employees speaking about any matter touching on their work. And you mentioned the very important case of Lane v. Franks, which I think makes abundantly clear that speech doesn't become unprotected just because it touches on topics related to your work. In fact, speech by government employees on those topics are especially valuable because of the expertise and experience that government employees bring to these discussions. But unfortunately, that's the position that the government has. The government takes the position this is unprotected speech because it touches on immigration judges' duties. We've not had a chance to actually have a court resolve that question because we've been stuck in a sort of no man's land. And I just want to make one further point before I leave off, which is just that, you know, NTU and many other older cases which involved First Amendment challenges to these sort of broad prohibitions on government employees speaking. You know, to the extent that those policies were challenged in earlier decades, federal courts simply assumed that they had jurisdiction to hear them. And so we know that these policies that exist at other agencies are, you know, at least in my view, clearly unconstitutional to the extent that they're just sort of a, you know, a blanket gag order on employee speaking. But we haven't been able to get real accountability because these days the government takes the position you have to go through these Byzantine administrative schemes that were never really set up to hear these claims in the first place.
Well, with that, I would love to invite Caroline Hendrie on behalf of the SPJ. Caroline, you just heard Judge Tsankov talk about that there's this multi-layer approval process that a judge must go through in order to grant an interview to the news media or give a speech to the public. Maybe you can explain from the perspective of the constituents you represent, the people who need that information, why these systems are so unworkable and what the SPJ is doing about it.
Well, thank you so much, Frank, for inviting me on this and giving us an opportunity to give the journalist's viewpoint on this really important topic. As you mentioned, Frank, we at SPJ have long combated the silencing of employees, particularly public sector employees, the kind of people who have vitally important expertise on matters of public interest. They're working at agencies that are supposed to be serving the public. So it's been a vital issue for us, and it continues to be. SPJ is an organization that promotes the free flow of information. And by design, the silencing of employees blocks public employee speech. It blocks the free flow of information. So it's just antithetical to what we believe is in the public interest. We've long spoken out against this. We see it as a problem for journalists. It certainly is. They're impeded from gaining timely access to people who are knowledgeable about the issues they're covering. But more important, we see it as a problem for the public. Open communication is crucial to bring to light information that the public needs to know. The public deserves timely and honest answers from public servants who know what they're talking about. We recognize that agencies are within their rights to authorize only some people to speak for the agency. Official statements are fine, but that doesn't mean that everyone other than authorized spokespeople can be banned from speaking to reporters, threatened with discipline if they do so, and just required to go through minders, getting everything approved in advance. We are absolutely dead set against that. One of the ill effects of these kinds of restrictions is that stories are heavily reliant on anonymous sources. Well, right now we're hearing so much and have in recent years about public trust in the media declining. Well, this works directly against public trust. If people are gagged from speaking, they feel their only recourse is to be an anonymous source. And often the public doesn't even understand what an anonymous source means. They think it means the reporter doesn't even know who the source was. That anybody can just say anything to a reporter and then it's fine. That's not true, of course. Anonymous sources are known to the reporter, but it just adds to the fog of confusion around trustworthy, ethical journalism. We see it directly contributing to this problem of lack of trust in media. So as Frank mentioned, SPJ has been very active on this issue. We've been active with research, with advocacy, and resources. Just to step back a minute on the research, Frank has been very involved in this over the years, but we have also sponsored 7 surveys of reporters and public information officers from different beats, including Frank mentioned that I used to be the leader of the Education Writers Association. So we participated with SPJ in surveys, both of reporters and PIOs on how much is this an impediment to the free flow of information. And we found overwhelmingly that it was, and I can go into greater detail on that. And since we did these surveys from 2012 to 2016, we really feel the situation has only gotten worse. We've also done projects such as the one Frank mentioned, Gagged America. I think the link was put in the chat, where we got the agency policies from 25 different agencies, most of them important federal agencies, but also some others, state level agencies, and 25 agencies. Almost half of them explicitly forbid employees from speaking to the press. 10 of them were very vague or internally inconsistent and contradictory, thus sending a very cloudy message and kind of deterring employees from exercising their First Amendment rights. And only 3 did not place any formal written speech restrictions on their employees. So those are examples of some of the research we've done. We've also done consistent advocacy, some of it in coalition with other organizations, gathering together dozens of organizations who are concerned about these issues, writing letters to federal employees or federal officials, in all sorts of agencies, demanding, meetings at the White House. And we've also issued calls to action, by journalists. And we've provided resources, for example, sample FOI requests for documents that are specifically related to the agency policies on communicating with the news media. So that's just an overview of some of the work that we've done. I know, Frank, you were interested in talking a little bit about the recent settlement in the federal case in Pennsylvania, the Brittany Haler case. Do you want me to talk a bit about that, or would you like to preface it? Or
why don't you?
Yeah.
And while you do that, I've got a link that I'll drop into the chat that goes to the Yale Law School First Amendment Clinic that was instrumental in initiating that case in tandem with SPJ. But please, give people an idea of, because it is, we've said a lot of discouraging things here about the experience of trying to get one of these cases in front of a judge, but it is actually possible to successfully litigate one. And there's some recent experience of a success story here.
Right, and great. And so, Frank, I'll just say that your work while at the Brechner Center, actually creating a roadmap for journalists to bring these kinds of cases, I think is really seminal. I don't think people really realized the degree to which there's ground for optimism that cases like this brought by journalists rather than the speakers could succeed. So I think that's a big contribution to the field. So in the Brittany Haler case, Brittany, a journalist in the Pittsburgh area, focusing on criminal justice, and was specifically spent years investigating the Allegheny County Jail and allegations of many problems. The deaths of men incarcerated there, exorbitant death rates, really kind of horrific situation. Vacancies of personnel, extreme staff shortages, a lot of turnover, really deficient medical care provided, just to the point that it was endangering medical professionals' professional licenses, a very serious situation. And she challenged this with the support of the Yale Law Clinic that you mentioned, also Reporters Committee for Freedom of the Press, who provide pro bono litigation support for journalists, was able to bring a case in federal court. And it resulted not in a ruling, but in a settlement that has some really encouraging language about the First Amendment rights of employees. And it resulted in the change of 4 different policies related to the jail employees' ability to speak to the news media, also their ability to speak on issues of public interest on social media. So it's being seen in our world as a very encouraging precedent, if not a ruling, a settlement that gives kind of wind in people's sails. And in the wake of that settlement last spring, SPJ has issued a call to action. We've said that journalists should use this precedent to consider similar legal action. They should also use it for discussions and editorials about restrictions on speech of public employees, use it to educate the public about the dangers of this kind of censorship. We often call it censorship by PIO at SPJ. So we've also asked people to join forces with other news organizations, press associations, news outlets, journalism schools, to demand answers from public officials and mount legal challenges in the wake of the Haler settlement.
Thank you. That's great. We've got some good questions in the Q&A already that I'm going to run down, but also encourage everybody watching to please add your own to the Q&A. But I had asked Ramya to take a look at the questions, a couple of different formulations of this one, but asking about the extent to which speakers are protected when they're active duty U.S. military. Maybe you could talk a little bit about your understanding of what the boundaries of the protections are there.
Yeah, so I mean, absolutely, active duty service members are covered by public employee speech protections. There was a question in there specifically about the First Amendment protections that service members might have when they share information that the government considers to be sensitive, whether it's classified information or otherwise marked sensitive. And, unfortunately, well, I can say that notionally, all of the principles that I articulated earlier apply. In general, courts have been quite deferential to claims made by the government about the harm that they suffer from the disclosure of classified information. And so, in general, I think, to the extent that courts apply the Pickering test, which, as I mentioned, is a sort of reasonableness analysis, or at least that's what it tends to reduce down to, where you are talking about the disclosure of information that the government considers to be sensitive, that will ordinarily shake out in the government's favor, even where there is a plausible, public interest in the disclosure. I want to mention one case that I was involved in, which is a First Amendment challenge to the government system of pre-publication review. So this is a system that involves America's many sort of intelligence agencies, as well as the Department of Defense. So it covers active and former service members. And essentially, these agency schemes prohibit employees, even once they've left government employment, from writing about their experiences in government topics which touch on their former government employment without the government's prior permission. So you have to submit your proposed writing, speech to the government and get their approval before releasing it. And we challenged this very far-reaching scheme on First Amendment grounds, arguing that it amounts to a prior restraint, invoking the NTU case that I talked about earlier. Unfortunately, we were unsuccessful in that case. NTU, as I mentioned, calls for pretty stringent medicine in terms of First Amendment analysis, but because these cases did involve national security claims by the government, claims, they were able to assert their interest in protecting the secrecy of classified and otherwise sensitive information. And as I mentioned, courts take that very seriously. So ultimately, we were unsuccessful in that challenge, and courts have tended to say, because government employees, and this includes service members, they sign contracts when they join public service, which prohibit them from releasing classified information. The courts have tended to say, well, you've essentially relinquished your First Amendment rights. You've waived your First Amendment rights by signing these contractual agreements. So that's sort of the state of play on that.
Yeah, and let me weigh in with a little bit more elaboration and invite if our experts from Office of Special Counsel want to talk at all about it as well, outside of the military setting, which I realize you don't work in. But there seems to be in the case law kind of a recognized distinction between the First Amendment right to share one's own opinions or life experiences on the one hand versus the right to actually purloin government documents and furnish them to outside third parties on the other hand, particularly if those documents have been entrusted to you in your employee capacity and you've been told that these are sensitive and not to be shared outside of the workplace, right? That the First Amendment is quite broad, but it's not quite that broad. And so while one could certainly say, right, even in the military setting, one could certainly say and invoke the benefit of the First Amendment, I am underpaid. My housing conditions are substandard. Those type of complaints about the way that military personnel are treated. If you had access to a sensitive internal memo that was entrusted to you that talked about those same subjects, and you furnished that to unauthorized outside parties, you may very well have departed from the protection of the First Amendment. And so, as much as people might like to recognize a broad First Amendment sort of right to leak, the courts have been reluctant to do so. And a follow-up question from a commenter was about, well, what if it's not work-related at all, but it is a comment on social media? This happens quite regularly, right? People want to talk about their political views or views on social issues, and they do so in an especially incendiary way that causes controversy and causes people to complain. And while there are strong First Amendment protections for being able to speak as a citizen about matters of public concern, Ramya alluded to the Pickering test there. In these settings, like a law enforcement agency or a military agency, it's sort of recognized that because of the need to maintain discipline and good order, that the same type of speech that one might be able to invoke First Amendment protection for, if you're a file clerk at the state DMV, you may not be if you're wearing a uniform. And so uniformed service members or uniformed law enforcement members seem to enjoy a diminished amount of elbow room to make comments of social and political controversy that raise questions about whether they are fit to discharge their duties. That's always where the courts seem to land, is, someone expresses a view that is taken particularly as, racist, homophobic, anti-Semitic. that logically might cause people to say, I don't believe you should be entrusted with governmental law enforcement authority or military policing authority anymore. And so that seems to be where the courts are landing. Hampton, others, do you want to weigh in on that as well?
Yeah, I'll say a couple things and welcome Emily's thoughts. There are constraints on my office's ability to receive and handle classified information, their carve-outs for national security information. However, we typically, certainly often, do receive documentary information from a whistleblower. So we would work carefully with the whistleblowers if it relates to classified information. We've got the intelligence community carve out, but we very much are in the business of receiving information in documentary form. And in terms of conduct outside the workplace, you know, the statutory phrase is conduct which does not adversely affect job performance. So there can be a lot of disagreement and discussion about what does and does not affect job performance. But Emily, do you want to add in on either the type of evidence we can comfortably receive or the issue of what is and isn't affecting job performance?
Right. Yeah, as you mentioned, OSC is generally quick to remind people that they shouldn't submit specifically classified information as part of their complaint, right? Because we certainly don't want to run afoul of any of the sort of storage and dissemination restrictions. But what we've found is, particularly in the whistleblower retaliation context, we can often determine whether a whistleblower has a reasonable belief without seeing the full scope of the classified information. An unredacted summary, a redacted summary may be sufficient for us to just determine that they had a reasonable belief in the wrongdoing that they reported. And in a retaliation context, that is enough in terms of satisfying those sort of initial elements of a retaliation claim. So the point is, there are ways to work through these issues as they arise on a case-by-case basis. So I would say be cautious with what you file right away, and then work with the assigned attorney to work out sort of an individualized strategy for sharing specific information.
Frank, I think you're on mute.
Thank you. So sticking with the folks from Office of Special Counsel, there are a couple of really meaty questions in the chat that I want to make sure that we get to. One question, and feel free, anyone who wants to weigh in on this, we know that while there are legal protections for whistleblowing, that it still sometimes happens. Happens quite a bit, that people get retaliated against. There are reports of this all the time. There's litigation about it all the time. What success have people had in challenging acts of retaliation? And I guess maybe what are some of the frustrations or obstacles that they've encountered in challenging acts of retaliation?
Well, I'll turn over to Emily for some examples. Certainly, if you go to our website, you'll see, I think, a number of cases, including a number of recent cases, where we've been able to obtain meaningful compensation to try to bring harmed whistleblowers as close to whole as possible. But Emily, do you want to give a couple of highlights?
Yeah, so there's the special counsel alluded to the fact that the Whistleblower Protection Act, which we enforce, is quite broad. And he was talking more about the fact that any disclosure to any source is typically protected absent, you know, a prohibition by law on the release of that information. But another way that the Whistleblower Protection Act is broad is the scope of personnel actions that are included, right? There are obvious examples in terms of, you know, a removal that we could get corrected if the evidence indicated that someone lost their job because of their protected whistleblowing. But we're also very cognizant of the fact that that's not the only way to chill whistleblowing within an organization, right? Much smaller actions can have the same effect, particularly where the whistleblowing is well known and done by a sort of high profile person in the organization. Simply removing some of their key duties, taking away sort of high profile collateral, interests and pieces of their portfolio sends the same message, right? And so all of those things are protected, and something that we would look to correct if someone brought a meritorious whistleblower claim to our office. So we want to look at both the big and the small, knowing that anything in those spectrum of personnel actions has the potential to chill not only that person's whistleblowing, but their colleagues' whistleblowing within the same organization.
And real quick, Emily, in terms of damages, damage awards, can you give some sense of either the dollar amounts or what types of damages are covered?
Yeah, and that's another way where Congress has sort of indicated that they want whistleblower protections in particular to be very robust, right? Because many of you who do federal employment law may be aware that there is a cap on damages in the EEO context. There is no cap in the whistleblower protection context. So there's not a lot of case law on that. It's very much developing. But those types of limitations are removed where a whistleblower has suffered various types of harm. And we would certainly look to fully compensate them as best as the law allows.
Yeah, just to add to that, because again, the legal protections at the state and local government level are perhaps not nearly so clear and so uniform and so dependable as at the federal level. One frustration that I think a lot of litigators, myself included, have encountered from time to time is that when you're litigating a disciplinary action or a discharge, often there is a mixture of reasons at play here, and the protected speech is only one of 5 or 6 different reasons that are given for taking that disciplinary action. So invariably, you're up against what some might call a papering the file problem, where the employer has figured out a way to document some non-speech motives for disciplining someone, and you're stuck having to litigate that, which is why getting back to the work that Knight Columbia Institute and Ramya do, it's so important to bring these facial challenges to broad policies where you're not tied up in the facts of any one person's particular discharge, which invariably get messy and complicated, but rather to try to strike down these restrictive policies on their face as unconstitutional without having to litigate any one person's individual situation. And so there's a really excellent detailed question in the Q&A that I want to encourage Hampton and Emily to maybe look at for a second, from somebody who's obviously really knowledgeable about the Hatch Act, more than me. But I also want to give Caroline just a moment to talk about, while the two of you are thinking about that Hatch Act question, Caroline, could you just talk for a couple minutes about the work that the SPJ is doing on the Press Act at the congressional level? Because like part of this body of protecting whistleblowers also includes making sure that journalists can protect the confidences that are shared with them by whistleblowers. So perhaps you could just talk a little bit about where we are there.
Yeah, that's so important. We're working with our allies, our press freedom allies, in the hope of getting this bipartisan legislation passed in the so-called lame duck session. We're utilizing a number of strategies. We feel like this really does transcend party, that vitally important information comes through confidential sources. We have so many examples of investigative journalists doing critically important work, bringing to light information that one party or the other would see as beneficial to their cause or not. It's been a huge issue across administrations, be they Democrat or Republican. So we very much are hoping that this legislation, which prohibits surveillance really, and of the government gaining access to the reporters' confidential sources through third parties, emails, phone records. It's really important but it has important carve outs for national security issues, threats of imminent violence, that sort of thing. So my understanding is the Department of Justice is in favor of the legislation, which passed the House unanimously earlier this year. It has unfortunately not advanced in the Senate. It's been in the Senate Judiciary Committee. But now there's some opportunities, we hope, to get it through, either potentially as an amendment on a larger piece of legislation, or also potentially, this is a smaller, probably a less likely option, but as a standalone piece of legislation. So, but we think it's vitally important. It's the best kind of journalist source confidentiality legislation to come along. It's been worked on over many years. It has a good definition of who a journalist is that does a good job of recognizing the evolving media landscape. So we're hopeful, and we're working hard to make it a reality.
Great, thank you. And I did share in the chat a link to the SBJ's resource page on the Press Act that explains what it is and why the organization thinks it is important. So just with the last few minutes that we have left, maybe our friends from OSC can both take a crack at educating us on the Hatch Act. And also, while you're at it, there is a question about explaining the overlap of jurisdiction involving OIG and OSC. So perhaps you can take a crack at both of those in 3 minutes.
Right. I'll speak quickly to the Hatch Act, in part because I'm currently litigating some major Hatch Act matters. And so I need to be circumspect. But and there's a lot on our website, because I've tried to be very public and transparent about why I've taken the actions I have on the Hatch Act. So on the issue of the effectiveness of the Hatch Act, as well as its constitutionality, I'll just say this. I think there very much has been a legitimate question about whether the Hatch Act has been effectively utilized against senior White House officials in the same way that it has been used against the 2 million other federal employees. And there is nothing in the statute, in the Hatch Act law, that differentiates between non-Senate confirmed White House officials and other government employees. And so that's why I am now, and I announced it 6 months ago, and we've actually brought a case against a senior White House official in front of the Merit Systems Protection Board, and we'll see what the court decides. In terms of the Hatch Act's constitutionality, I'm not aware the Supreme Court has ever questioned whether federal employees on the job can engage in express political advocacy, and nor am I aware of any Supreme Court questioning of the 24/7 prohibition on federal employees soliciting and raising funds for campaign. I mean, those are core tenets of Hatch Act prohibitions. And the case I'm bringing involves one of those tenets, the 24/7 prohibition on soliciting for partisan candidates. So again, we'll leave it up to the courts, and I welcome anyone to provide me feedback and to certainly look at the OSC website for more explanation. On the IGs, I'll just say quickly, we've got a very close, I certainly have a very close working relationship with the IGs. Emily's worked with them for years. They've got a key role and a role that we should all respect. But in terms of trying to protect a federal employee who suffered an adverse job consequence, it is OSC that is empowered by statute to go into the Merit Systems Protection Board. The IC work is separate. Emily?
Yeah, that's exactly right. OSC has the enforcement authority when it comes to those prohibited personnel practices. Where we intersect the most, especially in a whistleblower retaliation case, is that OSC has the authority by statute to investigate and seek the corrective action at the Merit Systems Protection Board for that retaliatory action. But what we don't necessarily do is investigate the substance of the underlying disclosure. right? So if someone says I was retaliated against for raising this particular public safety issue, often it's the IG that investigates whether that public safety issue was substantiated or not, right? So that's sort of where our roles are adjacent and may overlap.
Beautifully done in 3 minutes on the nose. Thank you for that. I need to wrap us up, but before I do, I don't want to leave without thanking, in particular, Catherine Foxhall from the Society of Professional Journalists. I see that she's commented in the chat, and she has really been a warrior for freedom of expression and has been really the OG on this issue that Caroline Hendrie raised about protecting the rights of public employees to speak to the press. And as she points out in the chat, this really goes beyond whistleblowing, and the protections of the First Amendment ought to be understood to apply even to just very ordinary workaday speech, like sharing your experience as a nurse in a public hospital, or sharing your experience as a police officer or a firefighter, even if you're not engaged in what we would term as whistleblowing speech. Unfortunately, there's some pretty good First Amendment case law out there, which you'll find on that Brechner.org website and in the resources that we have shared with you today. So with that, I need to thank our attendees first for joining us for this free ABA webinar, and to thank all of our amazing and wonderful speakers, Hampton Dellinger, Caroline Hendrie, Ramya Krishnan, Judge Mimi Tsankov, and Emily Collier for sharing their expertise with us, as well as the excellent resources. You're doing really important work. We thank you for taking your time out to share the benefit of your experience and knowledge. The ABA section of Civil Rights and Social Justice provides these periodic free webinars and resources for legal professionals and the advocacy community nationwide. And we hope that you find these useful in your work and shareable. So if you can, please consider joining and becoming active in the ABA at americanbar.org/CRSJ. Again, everybody who attended here will get an email that links you back to the video when it's available, and also to the resources that were shared in the chat. So best of luck, everyone. Stay safe, and thanks for being here.